In November 2024, the United States government made an extraordinary promise: full disclosure. The Epstein Files Act, signed into law by President Trump, was positioned as a definitive moment of institutional reckoning, a legislative commitment to release all documents connected to one of the most consequential criminal cases in modern American history. By February 2025, that promise has fractured into something far more complicated. The Trump administration has declared the release of 3.5 million documents complete, yet somewhere in the bureaucratic machinery of the Justice Department, 2.5 million files remain sealed. This isn't a story about individuals. This is a structural question. What happens when governmental transparency becomes selectively administered? The trigger event. The procedural tension didn't begin with the latest batch of files. It began with the legal architecture surrounding their release. According to public records, the original legislative mandate required the Department of Justice to publish all relevant files, with narrow exceptions for ongoing legal proceedings or victim protection. The framework was explicit: transparency as default, redaction as exception. Yet, as noted in cross-referenced media reports, the administration's interpretation of relevance has become the flashpoint. Todd Blanche, Deputy Attorney General and former personal attorney to President Trump, framed the final release as compliance. But compliance with what standard? The department claims 2.5 million documents fall outside the scope of relevant, a designation made unilaterally without external oversight or published criteria. Procedural breakdown. Here's where the mechanics matter. The Epstein case intersects with multiple jurisdictions: federal criminal law, civil litigation, international extradition protocols, and diplomatic immunity considerations. Each layer introduces legitimate grounds for confidentiality: medical records, attorney-client privilege, national security implications, all defensible reasons for withholding material. But the Justice Department hasn't published a categorical breakdown. You don't know which files are sealed for legal reasons, which are withheld to protect victims, and which might involve high-profile figures whose exposure could create political liability. As one civil rights attorney noted in public statements, the lack of transparency about the transparency process itself undermines institutional credibility. The broader implication for accountability. But was this a failure of policy or a deliberate choice? Consider the precedent. Congressional oversight mechanisms exist precisely to prevent executive agencies from unilateral classification decisions. The House Judiciary Committee, the Senate Intelligence Committee, these bodies are designed to audit what the public cannot see. Yet, as reported in institutional analyses, no congressional subcommittee has been granted full access to the withheld Epstein materials for independent verification. The administration's position is that prosecutorial discretion supersedes legislative review in ongoing criminal matters. The counter-argument advanced by transparency advocates and legal scholars is that Jeffrey Epstein's death in 2019 closed the central criminal case, transforming these files from investigative tools into historical records subject to Freedom of Information Act standards. Street-level translation. For the average American, this procedural friction might seem abstract, but the principle at stake is foundational. Can a democratic government promise full disclosure, deliver partial compliance, and declare the matter resolved? The Epstein case became a cultural proxy for institutional corruption, not because of any single proven conspiracy, but because the network of powerful individuals in Epstein's orbit represented systemic access disparity. Wealthy elites navigating legal accountability differently than ordinary citizens. When the mechanism designed to illuminate that disparity, the document release, becomes itself opaque, public trust erodes not just in the Justice Department, but in the viability of accountability frameworks writ large. First pattern break. You might ask, if there's no evidence of co-conspirators, as Deputy Attorney General Blanche stated, why does the withholding matter? The answer lies in what transparency achieves beyond prosecution. These files represent a historical record of how institutional failures in law enforcement, regulatory oversight, and diplomatic protocol allowed Epstein's criminal enterprise to operate for decades. According to victims' advocates, closure isn't defined by convictions. It's defined by understanding the systemic breakdowns that enabled harm. Without the full evidentiary record, that understanding remains incomplete, and the policy corrections needed to prevent similar failures remain unformulated. Victim protection versus victim agency. The Justice Department positioned victim protection as a primary justification for redactions. Yet, as documented in attorney statements following the February release, the execution exposed a fundamental contradiction. Gloria Allred, representing multiple Epstein survivors, reported that despite explicit assurances that victim identities would remain confidential, numerous client names, previously shielded under Jane Doe designations for years, appeared in the published files. This wasn't a marginal error affecting one or two individuals. According to Allred's public remarks, many survivors discovered their names exposed without prior notification. The systemic question: how does an agency tasked with protecting victims become the mechanism of their re-traumatization? The technical explanation involves the sheer volume of material. 3.5 million documents processed under compressed timelines create opportunities for oversight failures. But the structural explanation is more troubling. The Justice Department operated without survivor input in the redaction process. No victim advocacy panel reviewed the files pre-release. No notification protocol existed to warn individuals their information might be disclosed. As Allred characterized it, this represents either bureaucratic sloppiness or institutional indifference. And for survivors, the distinction is irrelevant. The outcome is identical: governmental betrayal, evidentiary standards, and public perception. The files released contain what legal analysts describe as high innuendo, low proof material, photographs of individuals in compromising but non-criminal contexts, email exchanges suggesting questionable judgment without establishing illegal conduct, unsubstantiated allegations that the FBI had already investigated and dismissed. Consider the structural problem this creates. In the absence of criminal charges, the document release functions as reputational adjudication by disclosure. Individuals like Andrew Mountbatten Windsor and Bill Gates find themselves defending against implications rather than accusations. Gates called suggestions in the files absurd and false. Elon Musk preemptively acknowledged email correspondence could be misinterpreted. The accountability gap. But what's the mechanism for correction when the government releases potentially defamatory material without prosecutorial follow-through? As noted in constitutional law frameworks, traditional libel protections don't apply to government document releases conducted under statutory authority. The individuals named have limited legal recourse. They cannot sue the Justice Department for disclosure of truthful records, even if those records create false impressions through selective context. This is the paradox of transparency without adjudication. You receive maximum reputational damage with zero opportunity for exoneration through formal proceedings. Street-level reality, the erosion of institutional trust. For ordinary citizens observing this process, the lesson is corrosive. The same government that promises transparency cannot execute it competently. The same government that claims to protect victims exposes them. The same government that releases evidence cannot prosecute based on it. According to Allred's assessment, survivors had little or no trust in the government before this release. Now, she states, they have no trust in the government because the government has not earned that trust. This isn't hyperbole. It's a documented institutional failure with measurable consequences for civic engagement. When victims of elite abuse cannot trust the justice system to handle their cases with basic competence, the deterrent effect on future reporting is profound. International implications. As cross-referenced in media reporting, the story is playing bigger in the UK than in the US, a revealing asymmetry. British public figures like Peter Mandelson, who resigned as ambassador to Washington following Epstein revelations, face accountability pressures in parliamentary systems with different disclosure norms. The structural difference matters. In the UK, allegations against high-ranking officials trigger immediate questions in Parliament, independent investigations, and ministerial resignations. The American system, by contrast, produces document dumps without institutional follow-through. The files reveal that Epstein sent $10,000 to Mandelson's partner for an osteopathy course, a detail that would trigger ethics inquiries in most democratic oversight frameworks. Yet there's no U.S. equivalent mechanism when the subject is an American official. Second pattern break. Why does jurisdiction determine accountability? If the same conduct produces resignation in London but silence in Washington, the variable isn't the behavior, it's the institutional infrastructure. This raises uncomfortable questions about whether the American transparency model, designed for post-Watergate revelations, remains fit for purpose in an era of international elite networks and cross-border criminal enterprises. The strategic outlook, trajectory, and endgame. The long-term trajectory, from disclosure to impunity. The pattern emerging from the Epstein files extends beyond this single case. It represents a template for how governmental accountability functions or fails in the digital age. Consider the systemic trajectory. A high-profile scandal generates legislative pressure. Congress passes a disclosure law. The executive branch complies selectively. No enforcement mechanism compels full release. The news cycle moves forward. Within 6 months, the story shifts from what happened to why isn't anyone being held accountable? Within a year, institutional memory fades and the precedent solidifies. Transparency theater substitutes for actual accountability. The strategic calculation. According to legal frameworks governing classified information, the power to designate relevance is the power to control narrative. The Justice Department's decision to withhold 2.5 million documents without categorical explanation creates 3 plausible scenarios. Scenario 1, legitimate confidentiality. The withheld files contain genuinely sensitive material, ongoing intelligence operations, grand jury testimony protected by Rule 6E, or information that would compromise victims. Under this interpretation, the administration is balancing competing legal obligations, and transparency advocates are demanding disclosures that would violate federal law. Scenario 2, political liability management. The withheld files contain information implicating current or recent high-ranking officials, and disclosure would create unacceptable political exposure. This isn't conspiracy theory, it's standard risk calculation in governmental crisis management. As documented in historical declassification battles, agencies routinely overclassify material to protect institutional interests rather than national security. Scenario 3, bureaucratic dysfunction. There is no coherent strategy. The Justice Department, overwhelmed by volume and operating under compressed timelines, made arbitrary decisions about what to release based on available resources rather than principled standards. This is the most mundane explanation and perhaps the most damaging to institutional credibility. The decisive endgame, normalization of opacity. Here's what the data suggests will happen. Nothing. The administration has declared the release complete. No congressional committee has successfully compelled additional disclosure. Victims' advocates are demanding full transparency, but they lack enforcement power. The courts are unlikely to intervene. Judicial review of prosecutorial discretion is highly deferential. Absent a whistleblower releasing the remaining 2.5 million documents or a future administration reversing course, this is the final state. Partial transparency presented as complete compliance. The systemic implication, the precedent, is extraordinary. Future administrations now understand that transparency laws can be satisfied through selective release, that victim protection can justify non-disclosure without independent verification, and that the definition of relevance remains unreviewable. As one institutional oversight scholar might frame it, the Epstein Files Act has inadvertently created a roadmap for avoiding accountability while claiming to provide it. Third pattern break, the broader question. So what does this mean for you? If governmental transparency can be promised, partially delivered, and declared sufficient without independent audit, what other accountability mechanisms exist only as performative gestures? Campaign finance disclosure, corporate regulatory filings, environmental impact assessments? The structural lesson extends far beyond the Epstein case. The emotional payoff, what this reveals about power. The Epstein files ultimately demonstrate not what powerful individuals did, but what institutional systems allow them to do. According to the evidentiary record, no co-conspirators will be prosecuted. The FBI investigated allegations against high-profile figures and found insufficient evidence. The criminal enterprise operated for decades, despite multiple opportunities for intervention by local police in Florida, by federal prosecutors in New York, by immigration authorities monitoring international travel. Each institutional checkpoint failed independently, and the cumulative failure enabled extraordinary harm. The future stakes. This is the endgame. We now know that institutional accountability depends not on laws or disclosure requirements, but on the willingness of agencies to enforce them against powerful interests. The Epstein files were supposed to demonstrate that no one is above scrutiny. Instead, they've demonstrated that scrutiny without consequence is merely visibility, and visibility without accountability is how elite impunity becomes normalized.